morning, my lord.
Yes.
Good morning, my lord.
Good morning.
I would like to mention WPC 29 of 2026 to be listed tomorrow.
Okay.
Thank you, my lord.
From motion, item number 1.
May it proceed, Your Lordship.
Yes, please.
Yes, I'm appearing for the respondents, Milots. I'm virtually appearing. I've been appearing in this matter for the last 20 years, so I appear for the respondents, Milots.
Respondent number?
All the respondents, Milots. I appear for all the respondents, Milots, here.
All respondent.
Yes, Milots.
Okay.
And my colleague Joey is already there, along with my colleague Bala, who's virtually joined me. So I appear for them, Milots.
Okay. So the respondents were to obtain necessary instruction in this regard from the government.
Milots, we have obtained and we have filed our wakalatnama also.
Okay.
So we can proceed, Milots. I just want to, if the lower court records are there, Milots, because I had filed my written submissions also there. If it is there, we can proceed with the matter, or I may be permitted to file a short counter because this has been settled till the Supreme Court. There is no occasion to invoke the jurisdiction of this honorable court, Milots, by way of a writ, because till the Supreme Court, the award has been upheld.
Okay. So now, notice can be issued then in that case?
Absolutely, Milots. My loss may issue notice, and I accept notice, Milots. I'll file a short counter.
Okay. By the way, what is your case?
My Lord, I will explain.
Even if it went to Supreme Court?
I will explain. I will explain. I am conscious of that. I have mentioned everything in my petition. This is with reference to two of my assets. I have many claims. All those claims are gone because of the Supreme Court order. But I have two assets. One is a guarantee bond given to them. Two, my machinery. My machinery was laying. They have no claim over it. Those machinery were laying there and sold, and we got around 1 crore. That is 99 lakhs. That is in a fixed deposit. That is my money. They have no claim over it. Therefore, but as they are taking time for a reply, Lordship may give me time, I will explain everything to Lordship. It is my duty to explain to Lordship that Supreme Court judgment and my claim has nothing to do with. That I will explain. Even today I can explain, no difficulty.
What matter went to Supreme Court then?
I will explain. First of all, Lordship, there was a contract. That contract was terminated by them. I say that contract termination was illegal. Whatever it may be, we have gone to arbitration. Before going to arbitration, when they encashed my performance guarantee, which is the subject matter of this case, I first came to this honorable court. This honorable court said, you cannot appropriate that money, keep it till the disputes are settled. And when the DRB was against us, again we approached the district judge, and district judge stayed the appropriation of that bank guarantee, keep it till the disputes are resolved. Thereafter, disputes arose between us because of termination. I had 10 claims, they had some 15 claims. Matter went to arbitration. So this order of these district judges that keep that money till all the disputes are settled between the parties. Now we went to arbitration. Arbitration, there are 3 arbitrators. Honorable Justice Saikia was the presiding arbitrator, and Justice Rajkova was our arbitrator, and one engineer was the PWD arbitrator. They held some 100 hearings. In the end, they made 3 different awards. Therefore, I filed a petition in the district court under section 34 of the Arbitration Act, challenging that there is no award because there are 3 different awards. But my argument was not approved by the district judge. I filed an appeal under section 37 before this honorable court. This honorable court, your lordships held that under the award, they said they did not make any award on claims and counterclaims. What the arbitrator tribunal held was, by majority, held was that they were doing the balance work.
They were doing?
The balance, because contract was terminated, so some balance works were there. So the arbitrator tribunal held, let them complete the balance work. Let them ascertain their losses. Then you can have the arbitration of your claims and their counterclaims. But it was not acceptable to me. Therefore, I filed appeal. And in the appeal court, my application was not allowed, but this honorable court held that what the award says is that when the works are completed, a new arbitration can be started where both claims and counterclaims will be decided. But they did not inform me, they did not make any claim against me, they did not start any arbitration, with the result that when the award is made, we have gone to 2 different ways. My contention was that this is not an award, therefore set aside and send it to another arbitrator tribunal. The arbitrator tribunal held, no, after completion of the work, you can start arbitration. Both ways it is correct. But I cannot go to the arbitration again because my contention was this is not an award, therefore entire thing to go to new tribunal. But I lost there. Therefore, that part is over. But this part, that after completion of work, you have to start another arbitration, which they should have started. They did not start because they don't know. They know that if they start arbitration, they may not win. I don't know. They did not start any arbitration. Therefore, there is no, with the result that my claim, once I lost up to Supreme Court, my claims are by that time barred by limitation. They did not start their arbitration even though the tribunal allowed and the Honorable High Court also allowed, they did not start. Therefore, their claims, my counterclaims, everything was barred by limitation. Now the question is that I have 2 assets. These 2 assets were protected by the district court under section 9 of the Act, saying that this bank guarantee will be kept for the arbitration. My money, this is my money. If they incur any loss and they establish in the arbitration, they can take it.
It's regarding bank guarantee.
Bank guarantee for performance. And if suppose I gave 10 crore bank guarantee.
What the agreement says about it?
The agreement says if they incur any loss, they can, clause 10 of the agreement says they can appropriate that money provided they incur any loss. That is stayed by the court saying that go for arbitration and prove your case. If they go into arbitration and prove their case, I have not difficulty. They are eligible to take that money. But if they did not incur any loss, if they did not make any arbitration, that money is my money. It's my money. That's number 1. I will come to the detail later. Therefore, this has nothing to do with the Supreme Court order. This is before arbitration, this order was made by the district judge saying that after arbitration only this money can be disbursed. You retain this money as separate. Therefore, they cannot appropriate that money.
This was not the subject matter before the arbitrator.
That I will explain.
No, Milord, this was
One
claim
second,
number
one second.
1.
Mr. Roy,
Sorry,
Mr. Roy, I am...
Mr. Thomas,
just a minute,
don't
just a
make
minute,
the
let him
incorrect
complete.
statement.
Mr. Roy...
Just a minute, let him complete.
Let me complete. First, I will take up the case of machinery. In the case of machinery, this was not a subject matter of arbitration. Machinery was mine. That I never paid any claim for machinery. I have made for some higher charges, etc. But I did not make any claim because machinery was mine. Already machinery was mine. I did not go for any case before arbitrator that my machinery may be given to me. Lordship, may kindly see the order. 303 is the order. In the end, Lordship, may I read this order?
Which order?
Page 303.
Order of?
Order of the London District Judge Iswal in connection with the post arbitration case number so and so, dated 7/7/2008. Lordship, got that page?
Yes.
That is a typed copy. The
Yes.
earlier page is the copy, but for the facility of reading, I retyped it.
Yes.
So I am reading the retyped one.
Yes.
Today is fixed for hearing the arbitration case number 7/7, filed under section 9 of the Arbitration Council 19 by the Bhagirath Engineering Limited. That is the petition. Both parties are present through their respective counsels. They are heard at length. Having heard the parties and on perusal of the available materials on record, especially as per memo number so and so dated 26/7/2005 by the project director PWD, Chief Engineer Highway Project, which stated that they have not taken custody of the plant, machineries and equipments of the petitioner. Therefore, the respondents are not responsible for their safety. Such being the situation, the question of release of the plant, machineries and equipments does not arise, since all the plant, machineries and equipments are already under the possession and custody of the petitioner. That is my custody. It is therefore needless to say that the petitioner has the right and liberty to utilize and dispose their plant and machineries as they like. So it is the order becomes final. No appeal by anybody. Therefore, this is my machinery. Now it is sold and kept in the bank account. So that is not a subject matter of arbitration, and I am entitled to get that money. They have no claim against me. They have no claim against me. If they had any claim, they should go for arbitration and get an award. Then only they can take this money. It is not there. Therefore, so far as the second item is concerned, it was not before the arbitration time. Now I will come to the first item. So it is clear. There is no need of any doubt about this. It is my money, my machinery and my money. And they did not have any appeal against this order. Therefore, once we sold this machinery with joint consent, and that money is in an escrow account, that money should come to me with whatever interest accrued. There cannot be any doubt about that. Now I will come to answer to the first item.
No, as per the order, it says that
This
the
is,
custody of the machinery.
I can use it whichever way I want.
Custody of the machineries and equipments.
He is
Petition-
with the
who-
petitioner.
who was the
That is-
petitioner? You.
I am the petitioner.
So then subsequently it was taken by them.
Earlier it was taken by them. By this order it was said, okay, you can take it back. Earlier order was there. Earlier order, the court said, you cannot, told me that you cannot take it now, this machinery. Let it be there as it is. That was early 2005 order. I can show that order.
What is the position there now regarding the machineries?
Machinery, now I say that this machinery is sold now with their consent. It is sold and
Whose consent?
the PWD consent. They were also there.
Okay.
And what we received was 99 lakhs rupees. Because it was laying there for 15-20 years
Okay.
with wear and tear, depreciation. In fact, it would have been 20 crore. But when it was after 15-20 years, it came down to 1 crore. Let it be 1 crore. That 1 crore deposited in the bank, in Yes Bank, in account, it is kept in there in 2021. It is lying there. So it is
Now
lying
also.
there.
Now also.
But, Lordship,
Now also.
Now also.
Okay.
It is renewed from time to time. So that is actually, machinery is mine. It is sold with their permission and consent. That jointly made, and that money is lying there. So I am asking that money. It is not a subject matter of any dispute before the arbiter tribunal. So I can make this request under section 151. There cannot be any doubt about it. So I am answering the Lordship's query. Number one. Number two, I have a issue because my submission is this. So far as for issuing notice, this is enough. If one is enough, that is enough. But the second, that is more important, is my bank guarantee bond. Lordship, may kindly hear me that the bank guarantee bond is given for this is my money. I am ensuring that if I make any sort of default and if you incur loss, this 10.8 crore you can appropriate. Otherwise, after completion, that is my money, I should take it back. So before start of arbitration, this is a subject matter of Section 9 petition before the learned district court. So district court said, keep this money separate and then you go for arbitration. I am answering this question that this was one of, I admit that this was one of my claims before the arbiter tribunal also, I admit. But that was aborted because they did not start any arbitration. Therefore, that money is lying there because that was ensured by the district judge before start of arbitration. That this money should be kept separate and after arbitration only this can be appropriated. Now, this money, the arbitration, neither I got an award nor they got an award. Therefore, the money is lying there.
Okay.
Then
Let us see your prayer once just.
Pray, Lordship, my kindness. My prayer is available.
Page 41.
I am obliged. Page 41. Lordship.
Okay.
May I read?
Okay.
In view of the foregoing circumstances, it is most respectfully prayed that this honorable court may be pleased to graciously be pleased to admit this petition and to quash and set aside the impugned order dated 28/11/2025 passed by the learned additional district judge Aiswal in CMA number so and so in miscellaneous application number so and so to the extent it refuses to release the performance bank guarantee amount of rupees 10.8 crore retained under the interim order. This is very important. This is not with reference to arbitration. Retained under the interim order passed under section 9 of the Arbitration Constitution 1996 along with interest and the sale proceeds of the petitioner's machinery amounting to rupees 19,38,000 deposited in the bank along with so and so. So these two are. So first kindly say A, I am reading A once more.
Okay.
The performance bank guarantee amount rupees so and so retained under the interim order passed under section 9. This has nothing to do with my claims before the arbitral tribunal. So this is retained under section 9 along with interest. So these are the two demands.
Okay. So you have this. So the respondent disputes this.
Yeah, Milos, absolutely, Milos. I'll just take my lords through this paperwork only. I don't know, all factually incorrect and misleading statements have been made, Milos. If my lord has page 199, the order under 37 of the Honorable Division Bench of this Honorable Court, page 199, Milos. If my lords has para 48 of the said order.
Yes.
Right, Milos? So it says, Milos, para 48, the order under 37, it says, on perusal of the summary of the claims referred to which are, the first claim is the return for the bank guarantee. And Milos, this has been declined right from the DRB, first by the High Court. When the termination was issued, they challenged the termination. They went to the Guwahati High Court. Guwahati High Court said nothing doing. Go back to the DRB, Dispute Review Board. Dispute Review Board upheld the termination. Then they went in the arbitration, Milos. Then the arbitration also upheld the termination. They held the, dismissed all the claims. They challenged under 34. I'll take my lords through also the 34 order as and when required. 34, it was dismissed. They went to the under 37 to the division bench, under 37 Milos, that there also it was dismissed, and it states in the DB order, it clearly says that refund of the bank guarantee was claim number 1, right, Milos? Now they went to the Supreme Court, which was also dismissed. Now, Milos, what my learned friend is asking, this Honorable Court to modify the award by way of this petition. Milos, even the Supreme Court, while exercising jurisdiction under what 42 doesn't modify the award. There can't be a modification, Milos. That's not permissible in law as settled by the Supreme Court. It has been modified till the Supreme, there is no modification. It can only be clerical or typographical error, Milos. Maximum. Courts are not permitted to modify the award under 34 or 37, even including the Supreme Court. This is one point. Second, Milos, I have raised a claim of 245 crore on him, Milos, which is the document he has not filed, which I had filed before the single judge in the 151 application. After the completion of my work, I raised a claim of 245 crore on him. This is the cost I have incurred for completing the work. And if at all he has a dispute, the remedy lies under the contract, not here. So he has lapsed because he did not respond, Milos. He did not respond because of the amount. And now he has lost that limitation. So he's trying his all options under 141 by way of a writ. My first prayer is, Milos, if he's aggrieved by my demand, which was issued to him way back, I'll just tell my laws the date. It was raised on 29th August 2011, Milos, after the completion of the award. And he has, instead of paying and exercising his right under the contract, and the right under the contract is a arbitration, Milos.
Just a minute. Where do we find the decision on this refund of performance bank guarantee deposit?
199, Milos, is basically the prayer. If my law says para 48,
Yes.
it says this is the DB order, Milos.
This
Refund
says
of
refund
Yeah.
of performance bank
Yeah.
guarantee.
Yes. Milos, I will make good, Milos, because there are documents he has not filed. I just wanted to give a couple of dates.
Let him file those documents. And we are not shying away, but Lordship may kindly say the earlier paragraph of this 198, page 198 of the order of this Honorable Court. This is my learned friend at paragraph 48. I am reading paragraph 47. Lordship may kindly see. Got it?
Yes.
May I read? This court, that is this Honorable Court, also finds that at paragraph 57 of the arbitral award, learned arbiter Justice Saikia had made the following observation with regard to the other claims and counterclaims. Can you see? Claims and counterclaims. See, on the question of claims and counterclaims, the following points may be relevant. In case of termination being found to be valid, whether the claimant can still pursue its claims. The solution may be that so long as those claims amount would enter in the cost and price of the stipulated contract work, those must await the completion of the contract. No interim cost may be awarded to it. Similarly, the respondent may also now should not make any claim except the cost caused by institution of the arbitral proceedings. However, dismissal of the arbitration proceedings ipso facto will not be a bar to the parties going to appropriate forum, will not be a bar to the same grievance. Now kindly show the balance portion. This is observation of the court. Thus, in view of the above observation, this court finds that when the majority award has found the termination being a valid at page 50, paragraph 15 and 61 of the arbitral award, the tribunal did not make any award. Kindly mark here, Lordship. Did not make any award on the 10 claims and 15 counterclaims referred to them, but had terminated the arbitral proceedings by stating that they cannot decide the disputes referred to them and that the parties could raise the same before a future arbitral tribunal once the balance work are being completed, that the issue of termination was to be decided first and then consequential reliefs to follow. My learned friend reading 48 and say, my claim is dismissed. It is not correct. All the claim can be subject matter of arbitration.
Okay, for the time being, what we'll do, we'll issue notice since he's
Yes,
accepting. Okay.
No, that's perfectly
Mr.
okay, Milos. But my only issue is, today I'm asking a question to myself, my lords. Can a court exercising jurisdiction under 226 modify an award? Because this award has been upheld right from day one.
So it is
And
not
Milos,
award. My learned friend repeatedly saying award. I say I am not asking anything under the award.
Okay. Hard,
saying
Mr.
that the award is upheld.
Hard, Mr.
George.
Joy Roy, Milos.
Okay.
Joy.
George Thomas. George Thomas.
George.
Okay. Land counsel for the petitioner. You are assisted by?
By assistant.
Okay. Land counsel for the petitioner, huh? So, also had Mr.
Joy Roy, Milos. Joy Roy.
Ajay
Happy.
Roy. Okay. Land counsel appearing on behalf of all the respondents. Respondent. Okay, respondent, huh? Para. The present petition under Article 227 of the Constitution of India is directed against the order dated 28/11/2025, passed by the additional district judge in CMA number 453 of 2025, arising out of Arbitration case number 47/2005 and interlocutory case number 369/2025, whereby the claim of the petitioner was rejected. Claim of the petitioner for, your claim was for,
Claim as mentioned in paragraph, in the prayer.
okay, the claim of the petitioner for release of performance bank guarantee.
It may not be the claim. Claim was before the tribunal, Milos, which was rejected. Because claim was their prayer.
That
was-
was the prayer given by
Yeah.
my petition.
No.
Okay.
Mr. Thomas, can you have a patience for 1 minute? Milos, the claim was filed before the Honorable Tribunal, Arbitration Tribunal, Milos, which was rejected, and it was rejected by 34-37. So they had filed a prayer for release
on
of
the
this
ground that
performing.
the subject matter, okay, on the ground that the subject matter stood concluded in arbitration proceeding and subsequent judicial, and by the subsequent judicial forum, including the
Honorable Supreme Court, Milos, on 6th of
District
September.
Judge, the Honorable High Court and the Honorable Supreme Court of India, and also on the ground of lack of, it says that pecuniary jurisdiction to entertain the application. Stop. Para.
Lordship Lordship may also observe that I dispute this proposition. Because
So
that
no,
is what
what
is
I'm recording is rejection, the ground for rejection only.
all right,
Okay.
all right.
Okay. So according to you, it was not the subject matter?
Not at all, no,
Okay.
because I have
The
read
non-com-
paragraph 47.
Okay.
No,
The
I
non-counsel for the
dispute that,
petitioner
Milos. I
submits
dispute that.
that
I dispute that.
the learned additional district and session judge failed to exercise the jurisdiction vested upon it. Okay, stop. However, the learned counsel for the respondent submits that the matter has attained the finality. Since the matter has been decided by the arbitration tribunal, the district and district judge, the High Court and the Honorable High Court and the Supreme Court, and it has attain the finality. Stop. Para, the dispute between, no, just a minute. In his submission, the dispute between the parties has attained a finality. Okay. The matter requires examinations. Para, the matter requires, upon hearing the parties and on perusal of the, hearing the parties, this court is of the opinion that the matter requires examination. Stop. Accordingly, issue notice. Since Mr. his name
Ajay Roy.
A. Roy, Ajay Roy, Land Council, appeared and accepted notice on behalf of the respondent. No formal notice need be issued. There is only one respondent.
On our spot.
Okay.
Yeah, but basically it's the same, Milos. The state of
Okay.
Mizoram and the PW engineer. I appeal for both, Milos.
Okay.
It's the government.
No record need to be called for?
Not record.
Lower court records, I have filed my submission, if my lords.
Okay.
Because,
And-
I
okay.
don't think the records
Notice,
may be called for.
Who further submits that he would like to file reply
Reply, a short affidavit, Milos.
and sought for some time. Okay. Prayer allowed. List this matter after 4 weeks.
For Lordship,
Very
give
well.
me file a small rejoinder also. If
Okay.
you file a rejoinder also.
Okay. In the meantime,
In the meantime, after receipt of his reply.
okay. So, in the meantime, the petitioner.
Within 2 weeks.
Okay. Okay, the prayer is allowed, allowed. The respondent may file their reply within 4 weeks. Within 3 weeks. 3 weeks.
Very well.
3
Yeah,
weeks.
Milos, that's perfectly
And,
okay.
And copy be served to the Land Council for the petitioner. The petitioner may also file rejoinder. Okay, stop. Para. List this matter after 4 weeks.
Very well, Milos. Grateful, Milos, obliged.
Item number 2.
Deeply obliged.
Deeply obliged, Milos.
May I please, Your Lordship? May I please, Your Lordship?
Yes.
My Lord, this is IA number 63 of 2026. Am I audible?
Yes. Okay, so,
This is IA number 63 of 2026, my Lord. This has been filed
okay, you want to withdraw?
in 7. As it suffers,
No. Now you are not audible. You are assisting.
No, my lord, I am for the petitioners in the WPC, my lord.
Okay, WPC. So, have you received the copy of this
Yes.
IA?
Yes, I have received, and I would like to submit my objections, my lord.
You want objection to this?
Yes, my lord, because there is no provisions of law that has been invoked for the withdrawal, plus they have already been,
It is in the initial stage, but
my lord, they have not invoked any provisions of law for the withdrawal itself. Plus, if we look at the petition for the application for the withdrawal, my lord, no provisions of law has been invoked.
what provision of law?
The IA, my lord.
So they are seeking leave of leave
Yes.
for withdrawal of the
withdrawal.
affidavit in opposition due
More
to
of-
formal defect. Due to formal defect, that can be allowed.
My lord, they have also been allowed to file their amended counter affidavit. If they may file additional affidavit, my lord, this affidavit in opposition has already been filed under oath.
So
if
no,
may be
they
allowed
say
to file
there is a formal defect in it, in the affidavit in opposition filed by them.
It would cause
There is a formal
prejudice, my
defect.
lord.
That
It
can
would-
be.
Yes, my lord. However, it could cause.
Yes.
Lordship, in the earlier affidavit, Your Lordship may come to my lord, paragraph 2, where we have said that being General Manager P and the respondent number 3, But my lord, the respondent number 3 in the writ petition is the state of Mizoram. And General Manager P himself is not a party, but inadvertently, my
paragraph?
lord, the paragraph 2, my lord,
Okay.
of the affidavit filed earlier.
Interlocutory application?
No, my lord, affidavit that
No,
was already
affidavit.
on record. my lord.
Affidavit in opposition?
Affidavit. Lordship, my lord. Paragraph 2.
Yes.
So that being the General Manager P and the respondent number 3 hearing. But if your lordship looks into the respondents in the writ petition, respondent number 3 is state of Mizoram,
Oh, see?
and General Manager P is not a party at all. But inadvertently, my lord, this mistake crept in.
This is formal. This is formal only.
No issues, my lord.
Okay.
Just
This is
switching my
formal only,
Formal only. So that is
And
the,
in
this can
fact-
be allowed. Okay.
Lordship. And
Okay.
in fact, by the earlier order, this court has allowed me to file additional affidavit if so advised and etc. matter. But it will be
Okay. Well, let me pass order in this interlocutory application first.
Lordship matter.
Okay.
And sometime may be granted to file my affidavit in opposition. Afresh.
Okay. Hard, Mr.
I'm psychiatric.
Msaike, Land Senior Counsel. You are assisted by?
My friend there, madam.
Okay. Who assist? Who is assisting? Mr. Saike?
My lord,
Lordship.
and Nirola is there.
Okay.
M. Nirola, Lordship.
M?
M.
Right.
Nirola, Lordship.
Okay. Land Counsel for the applicant. Staff on para. By filing this interlocutory application, the applicant is seeking leave for withdrawal of the affidavit in opposition filed on behalf of the respondent number 6 and 7 in the above in WPC number 47/2025 due to formal defect with a liberty to file afresh. The council also submitted that no prejudice will be caused to the petitioner as the defect is a formal stuff. The prayer so made by the Land Council for the applicant has not been objected to by the Land Council. Miss
Valentina.
Valentina, Land Council appearing on behalf of the respondent staff. Accordingly, the prayer is allowed. The applicant is allowed to withdraw the affidavit in opposition filed on behalf of the respondent number 6 and 7 with liberty to file afresh by the applicant. Okay, with the above this, I stand allowed and dispose of. Okay.
Matter will come up on 27th of April. Madam.
Hmm?
I'll file by 27th of April. Matter will
Okay.
come up on
Okay. The allowed to file fresh within 2 weeks. 27.
3 weeks. Madam.
3 weeks.
It will be 3
weeks. Okay, within 3 weeks. Okay, with advance copy to the Land Council for the petitioner. Okay.
Lordship.
Okay. List this matter after 4 weeks.
After 3
My
weeks.
lord, on 27th of April. Madam. 27th of April.
27.
Lordship.
Just a minute. Then hard same. Huh? Okay, in view of the order passed today in IFC number 63, the petitioner is allowed to file. The respondent number 6 and 7 is allowed to file written, affidavit in opposition within 3 weeks. Okay, stop, para. A is prayed for, comma, list is matter on 27 of
April.
April, okay. Just a minute, huh? Earlier, you were also allowed to, probably,
Yes, sir. Additional affidavit, my lord.
additional affidavit. So
Right.
now, additional affidavit is no longer required? Additional
Lodge,
affidavit by
madam.
whom?
By us only, my lord.
Now, since you are, you will be filing a fresh,
Allowed-
no additional affidavit is required?
Yes, my lord. I will incorporate whatever my lord additional wanted to put, my lord. I will incorporate here, my lord.
Okay, that's fine then. List is matter after 4 weeks. Okay.
Lodge. Obliged.
Obliged.
Item number 3.
My lord, in this case, I am for the respondents as a legal aid. So, my lord, if lordship will see that at page 56, my lord, only the segments of the charge sheet has been annexed.
Just a
So,
minute, revision. Okay,
so only the segments of the charge sheet has been annexed. So, my lord, to effectively assist the court, I would like to peruse the trial records and hopefully give a proper assistance to the court. So, in that case, my lord, I seek 2 weeks' time for further preparation. The records have arrived, my lord.
record. This is,
NDPS, my lord.
hmm?
NDPS case.
From the revision. You are for respondent.
Yes, my lord.
Okay, you are challenging the discharge order.
Yes, Lordship. We are challenged.
Have you received the record? Is it available? Okay, so okay, hard, Mr.
L. Mangaisanga. And Lordship, I am appearing on behalf of my senior Mr. Johnny L. Tauchong.
Okay, for the union,
Yes, Lordship.
Lara Council appearing on behalf of Mr.
Johnny L. Tauchong.
Johnny L. To Chong,
Yes, Lordship.
Lara Council for the petitioner. Stop. Also heard Mr.
Lord Rokunga Pautu.
Lal Rokunga Pautu, Legal Aid Council for
Yes, my lord.
appearing on behalf of Legal Aid Council for the respondent 1 and 2.
Yes, my lord.
You are praying for some more time.
Yes, my lord. And my lord, as I have mentioned, to have an insight of the procedural flaws, my lord, I would, if lordship would kindly allow me to have a scanned copy of the
Okay.
charge sheet, my lord.
And who submits? And then who submits that? Who prays for scanned copy of the record? To go through. the matters. Stop, huh? Para. The registry shall furnish a scanned copy of the relevant record to the learned legal aid counsel appearing on behalf of the respondent within 2 weeks. Stop, huh? List this matter after 2 weeks.
My lord,
Okay?
I'm obliged.
Within 2 weeks to enable him to go through the same. Huh? Stop. List this matter after 2 weeks. Okay.
Deeply obliged.
Item number 4.
My lord, item number 4 is
My lord, I'm for the respondent. The leading counsel, Mr. Victor Eralte, my senior, he's having some personality difficulties. So if the matter may be listed after 2 weeks.
Okay. This week, huh? You are for the petitioner?
Yes, Lordship.
Applicant?
Applicant, Lordship.
Probably you have received the copy, the amended,
Yes, Lordship.
you received the copy?
Yes, received.
You have an objection?
No, Lordship.
Then in that case, we can allow this.
No, I mean, Lordship, for hearing, it can be listed again.
Hmm?
Hearing of the application. We already filed the objection.
You have already filed?
Yes,
Okay, objection to the condonation of the...
yes, yes.
Okay. Had Mr.
Well, mga isa nga.
Learning counsel for the applicant. Your name is there?
No, my lord, I'm appearing on behalf of my senior, Mr.
Senior is?
Johnny L. Tauchong.
Johnny Tochang.
Yes, lordship.
Your good name you said?
Lal mga isa nga.
Learning counsel appear on behalf of Mr. Johnny L. Tochang. Learning counsel for the applicant. Staff. Miss
Bilal Ram Nemi.
Learning counsel. B. Lal Ram Nemi.
Nemi.
Okay, learning counsel for the respondent. He is also present, staff, and submits that they have already, she has already filed written objection, staff. Since the parties are duly represented and represented, and the affidavit also, which affidavit also filed, let this matter be listed for admission.
No, hearing for the delay condemnation.
Okay, okay. Hearing hearing on the hearing.
Application, we have,
Hearing of the application. Okay.
Yes, lordship.
Hearing of the delay condemnation application, huh? Okay. After
2 weeks.
2 weeks. Okay.
Item number 6.
Lordship, in this matter also, similar order may be passed.
Okay. This is similar only. Right. Okay. Similar order, huh? After 2 weeks.
Item number 7.
If I may,
Just a
my lord.
minute. Okay. Well, why there are so many IA here in this case?
Yes, lordship. By filing this appeal, there
No,
is
some of the
requirement-
IA, since you have already filed the amended,
Yes, my lord.
the earlier IA, what is this IA 41(4)? Not 41. IA 30, IA criminal 30 and criminal 20, and 28.
Lordship,
Probably 21 is the amended one.
IA is delay condemnation for an application for
Special leave.
special
Okay,
leave.
okay, what we'll do at the time of disposal of this IA, the entire IA also will be disposed of. Okay,
Yes, lordship.
it's fine then. Okay. Yes, sir. This is item 7.
My lord, in this matter, I'm still awaiting and the order sheet of the trial court, my lord, where the judgment was pronounced in the open court. So I would like to attach that on along with my objections. So the same is still awaited from Sampai district.
You're awaiting?
I'm awaiting a certain document, my lord, from the CJM, which application has been filed and it's pending, my lord.
Okay, so
with
these
that, my lord,
also-
I seek another 2 weeks.
Here also the proper application was not filed.
Correct, my lord.
Section 5 of the Condemnation
Section 5
Limitation
was
Act
not
was
invoked,
not
my lord.
inserted, but subsequently you have filed. Have you served copy? Have you received?
Yes, I have received the copy.
Okay, now,
Now the only issue is that, my lord, I'm still awaiting a certain document from Sampai Judicial,
documents from the,
Sampai CJM, the Chief Judicial Magistrate, my lord.
what
Which I would
document?
like to, the order sheet wherein the judgment was pronounced in the open court, whether they were actually present when the judgment was pronounced.
Okay.
So I would like to
Whether
attach
record
that.
was called for?
It has not been called as yet, my lord.
You want the record to be called for?
Not at this stage, my lord. I will
You are-
file my objections.
Have you
first.
applied?
I have applied, my lord.
Okay, you are waiting for that.
Yes, my lord, it's still pending.
Okay. Mr.
Lal mga isa nga.
Learned counsel for the applicant. Also had Mr.
Laro ko mapau tu.
Learned counsel appearing on behalf of the respondent who prays for some time on the ground that he has applied for a copy of the order sheet,
Yes, my lord.
certified copy of the order sheet from the Learned Trial Court, and which is still awaited. Stop. Prayer allowed. List this matter after 2 weeks.
My lord.
Okay.
I'm obliged.
Item number 8.
Lordship, I'm appearing for appellant hearing. We haven't received a paper book yet.
Okay.
Yet.
Okay, amicus.
Try for the
Okay. You are Miss H.
H.
Lalman
Lalman
Swami.
Swami, yes.
Swami Lanet amicus for the appellant. Also had Miss Linda Lanet PP for the state. Huh? Staff. Huh? The paper book. Hey, have you received, Miss Linda? Have you received?
Not yet.
I
Okay.
don't think the paper book has
Paper book
been
otherwise ready?
prepared
Copy
yet.
available?
Not yet, not yet. Trial court,
This I think is a paper book. Hmm? It's available now. Okay. Since the paper book is ready, let a copy of the paper book be furnished to the Lanet PP as well as Lanet amicus as well as Lanet PP. PP, huh? Stop, huh? Since the parties are duly represented and the paper book is ready, let this matter be listed for hearing after a week or two.
After 2 weeks, Lordship.
After 2 weeks. Okay.
item number 9.
May it please my court, my lords. I appear through VC in this matter. Am I audible to my lords?
Yes, yes.
My lords, this is a bail application under the NDPS Act. Here the accused, who is a driver of the vehicle, was arrested for alleged possession of narcotics, heroin to be precise, and the amount was 1.310 kgs, my lord. And I was arrested way back in the year 2023, my lord, 25/8/2023. And the main grounds which I have raised in this bail application is that while providing me with the seizure and arrest memo, I was not provided with the grounds of arrest. And neither were the notices served upon me as well as my relatives, which was mandated under the CRPC as it was then. And also in the light of the Honorable Apex Court judgment in Pravir Purakashchan Vihan Kumar, it is now a settled law that the grounds of arrest has to be communicated.
We'll see the record, Ms. Linda.
Yes, my lord, this has come up for the first time.
Okay. Heard Mr.
A. Borua, my lords.
Learned counsel for the petitioner. Also heard Ms. Linda, former learned PP for the state staff para. This is an application filed under section 483 of the VNSS 2023, seeking grant of bail to the accused Ali Hussain, who has been arrested in connection with
Well, this is the sessions registration
session
case.
registration case number 388/2023, arising out of which PS case?
My lord, this
Under section 20. Have you filed bail application before the session court earlier? Special court?
Not in this case, my lords, no.
Not filed?
No, my lords.
You have
This
to
is the
file
first-
there first.
My lords, the only problem is that, my lord, the matter had arisen long back, and due to the financial
No.
incapacity of the...
You have not yet filed any bail application before the trial court?
Not to my knowledge,
No,
my
no.
lords.
Yeah, you
First
have to file
application.
bail application before. You have to first
my lord,
file bail application before the trial court. Trial court is the right, the appropriate forum, appropriate court who can grant,
my lords,
who
if
can
I may
consider your bail.
My lords, if I may humbly submit, there is no bar for this honorable court to exercise...
There is no bar, but you have to exhaust
Or-
first. The lowest court.
My lords, I bow down to that, my lords, but the
What is
that,
the status of the case?
my lords, it is at a very advanced stage of trial, my lords, and therefore
See,
perhaps
that is why I'm saying. That is why you first
my
try it
lord-
before the trial court. No.
My lords, because it is at such an advanced stage of the trial, therefore, my lords, we have
Advanced
directly
stage means
approached
any evidence recorded?
Yes, my lords, the
See, then
depositions have
the
been recorded.
right court, the proper court would be the trial court. Trial court knows whether bail is to be granted to you or not.
My lords is calling for the TCR, my lords. It would be very clear from the records.
How can we consider unless you first trial before the file a bail application before the trial court? It is before the trial court only. The trial began, trial started.
Yes,
Now
my
the
lords.
trial court is the right court who can consider your bail application.
My lords, I bow down to that, my lord.
If the trial court reject, you come before this court.
My lord, I fear that, my lord, in this case, if we approach the trial court first, it would really be quite a delay, my lord, on the part of the
Where
client.
is your statement that there is no any case pending against you in any other court?
My lords, at para 16 at page 11, my lords.
Well, kindly read it. Where? Your antecedent.
My lord, the accused petitioner most humbly submits that no other bail application is pending before his honorable court or any other court of law seeking regular bail to the accused person except this instant bail application.
No, this is no bail application is pending. But
Yes,
then
my
where
lord.
is your antecedent is saying that no any case?
My lords, we come to
Against-
para 13. Para 13 at page 10, my lords.
Para?
13, 1-3. At page 10, if I may read, my lords. that the accused petitioner humbly states that he is a permanent resident of the above mentioned locality and belongs to a
Okay,
well-regarded
not,
family
prior criminal
and has
antecedents.
no
Okay.
prior criminal antecedents, and as such there is no possibility of him escaping the trial of the matter if he is granted the privilege of bail.
See, unless,
Yes.
ultimately,
I really bow down to my lord.
ultimately, even if the record is called for also, this court
My
will
lord.
direct the trial court to consider. This is
my
not a
lord-
proper way.
Yes, my lord. Let him
My lord,
exhaust all the
in
remedies
this
first.
case,
Hmm?
I lost.
Let him exhaust all the remedies first.
Yes.
My
Ultimately
lords,
this-
my lords, with folded hands, my lords, I pray that
No,
let this honorable court
don't
exercise
go
its
for the,
power.
don't go for the easier, don't go for the easier way.
My lords, this is not the easier way. This is the most expedient way, my lords, as of now, because the trial is at an advanced stage, and therefore, if we go to the trial courts, and if for some reason it is
See,
not
you are
allowed, my lords.
are you appearing before the trial court?
Yes, my lords. I'm
Then
appearing.
what
my
is the problem?
My lords, the problem.
What is the
that my
problem?
lords-
Because the trial court knows whether to grant you bail or not. How do we consider by how do the High Court consider your bail whether you are entitled or not?
My lords,
Unless
it
we
will-
know that some observation being made by the trial court.
My lords, it will be borne out of the records, my lords. My lords have the full satisfaction of going through the entire records and the depositions and all of it, my lords, right from the beginning of the trial. So there would be no impediment in my humble submissions, my lords. And also considering the financial constraints of the accused, my lords, he is
Okay.
a truck driver who has been in detention for 3
That
years,
is-
my lords.
See, financial
Therefore-
and you are already appearing before the trial court and financial, you are talking about the financial constraint. Filing before the High Court, what we feel is more expensive.
Yes, my lords, hence the accused deemed it fit that
okay,
if
okay.
my lords is approached for this bail application, it would be a more expedient way to be heard, my
The
lords.
learned counsel for the petitioner submits that he has not exhausted not filed any bail application before the trial court, nor be that as it may, let the record be called for. A scanned copy of the trial court record be called for. Leave the first line then. Leave that one. Or call for the trial court. Call for the scanned copy of the trial court record. Stop. List this matter.
My lord, may I pray that it may be fixed on the 10th of this month if it's convenient to my lords?
After where? How long it will take, Miss Linda?
My lord, it's in Aizawl, so it will not take long. But many
lord,
cases are
nearby.
already fixed on 10th, my lord.
Okay.
And
On the 10th, my lords, if it pleases.
if it can come up after vacation, my lord, many
Okay.
cases are already
On 20,
pending.
okay.
My lord, may I pray on 21st, my lord, in that case?
21st, okay, 21st.
Yes,
Item number 12.
My lords, in this matter, I appear again, my lord. It arises out of the same case. Here, the petitioner is the handyman of that vehicle which was seized. And my lords, in this case, my instructions are that a bail application was filed before the learned trial court, which was dismissed.
Okay. Mr.
A. Borua, my
A.
lords.
Borua, learned counsel for the petitioner, also had Miss Linda, learned PP. This is an application filed under section. Same order. 483 of BNSS 2023, seeking grant of bail to the accused Sebul Haq Barbuya, who has been arrested and facing trial in connection with the session registration case number 388/2023 under section 21C of the NDPS Act. You have not mentioned the PS case also.
My lords, I did not get, my lords.
Hmm?
My lords said something, my lords.
You have not mentioned the police station case also, arising out of which police station case?
I apologize, my lords. I will just have it.
Not mentioned. Hmm?
My lords, it arises out of.
Okay. leave.
Excise case number EXN 239 of
Okay.
2000.
Arising out of excise case number EX.
239.
Where do I find?
Minus page 20.
It should have been mentioned in the course title only.
I apologize, my lord. Since it was under trial, I thought I would mention the case number. I apologize, my lords. Page
It
20,
says
my lords.
case number EXN 239/2023. Okay. Call for the scanned copy of the trial court record. Staff list this matter on 21st. Okay.
21st.
I'm so obliged, my lords.